But the two cases that are interesting to me are Scales versus Benny, and the cite's in there. It's a First District case. And ironically, both of these cases have the same trial judge. But in this case, this is an auto case, but I think it has potential ramifications for us, and it deals with how we should strategically think about doing things. So in this case, it's an auto versus pedestrian, a guy trying to cross the street at North and Clybourne. And one of the issues was whether or not he was in the crosswalk and some issues associated with the size of the car. At trial, for the first time, the plaintiff disclosed or tried to use, or right before trial, tried to use photographs of the car and the intersection. And as you might expect, the defendant screamed bloody murder, said we had a 214 request, the typical 214 request, and you can't use the photographs, and the judge granted it. On appeal, the plaintiff's reasoning or excuse for not disclosing it was 213G, one of the subparts in 213G, which talk about use of or eliciting opinions on cross-examination. Now, he was trying to use this and the adverse examination of the defendant. The appellate court distinguished the use of or eliciting of opinions in 213G from a request under 214. And in that case, there's some clear language that if there's a 214 request for documents that you're going to use on cross-examination, on adverse examination, they need to be produced. So when I read that case, I immediately thought to myself, because sometimes I do this, is I want to withhold on the cross-examination of a defendant or an expert, I want to withhold some articles. I want to withhold, even if he's got a huge CV and I go through his entire CV and I want to pull out one article, and then I look at my 214 request in med-mal cases, they're always detailing, we want everything you're going to cross-examine anybody on, et cetera, et cetera. This case could be a problem for us if you're going to take the position that you're not going to disclose a medical journal or not disclose potentially even something on a defendant's CV or a defense expert's CV. They're going to bring this Scales case up and say, listen, you can't rely on 213G. There's a 214 request out there, and you didn't comply with it. So I, myself, am going to be real careful with the way that I deal with that, because those documents oftentimes are the most explosive things you can use on cross if you're lucky enough to get one. The other case that's interesting and is a must-read is this Taylor versus County of Cook. And there's a multitude of issues in this case. I feel bad for the plaintiff's lawyers that were involved in this case, because it was a difficult situation. So this is a med-mal case. The plaintiff alleged some improper treatment by 3 docs in Cook County Hospital. The two issues that I want to talk about are one, cumulative evidence. So what happened here is the defendants, the defendants, both the hospital and the doctors, were all going to disclose an expert with the same specialty, and each defendant had an expert in that same specialty. So there were multiple experts, rheumatology experts. They were all going to testify against the plaintiff, and the plaintiff tried to stop that by claiming it was cumulative evidence, and the court came out and very clearly found that each defendant is entitled to their own expert. Now, 4 years ago, I had this same argument in front of a judge in Cook County, and they granted my motion and said it was cumulative evidence. So to me, at least from my experience, this is clearly a change in the way that you're going to have to deal with things. The other thing that it makes me consider, that I now always consider, is, do I really need to name all these defendants? Do I really need to deal with 4 defense lawyers? Do I really need to deal with 4 experts on the same issue? I mean, you're going to get, to me, I feel like I'm going to get pummeled if I hear over and over and over again they get 4 bites at the apple ultimately to find the right expert that appeals to the jury. So in certain instances, there's nothing you can do about it, but in my humble opinion, I try and limit the number of defendants I have in the case if I can, because I don't feel like I really want to deal with that number of experts, nor do I deal with that number of defense lawyers questioning my client and my experts. This case just reinforces it for me. The second issue in this case deals with the impeachment of an expert on his personal practices. And hopefully this is a very case-specific situation. So what happened here was, in his deposition, the defense expert was questioned about what was the proper treatment for this condition called severe polymyelitis. What he said, and you can't tell obviously from the case, you can't tell the complete context of it, but what he said was there was 3 possible treatments that complied with the standard of care, but then his personal practice, he always did X. And X clearly appears to be the treatment that likely is the most aggressive treatment. I went and looked up this condition after I read the case, and it appears to me to be the treatment that most people follow. So what the plaintiff wanted to do was impeach this expert on the concept that what he was doing versus what he was testifying was not consistent. The court denied it, saying that was improper because this expert had testified these were all types of treatment that met the standard of care. While you can't understand this case completely without reading that depth, what it says to me is that you have to really push forward with questioning on that issue. I mean, why did he follow only this course of care and not the other 2? Why? It had to be because A, he was more successful with it, and B, he was aware that it was more successful overall in treating this condition. So I think if you get to that next phase, you will be okay and you will be able to cross him on this. But just having him say these meet the standard of care, you're going to get stuck with this case now. Last issue, and I'm a quick speaker, get to the point, Kevin Burke-like. F2s. So I have been going crazy in my mind because we haven't been having as much problem with F3s, is getting F3s done. It's getting to F3s that's the problem. Is you file the case, defense files some stupid 2615 motion, or they take their sweet time answering the complaint, and then they go in on a motion to vacate, then they send out discovery 29 days after that, and then they wait. They don't answer your discovery on time, et cetera, et cetera. So you never get to F3s until well down the road. So I don't know how long ago Judge Kogan started this, but I adapted this for my office now. I remember when I first came into Judge Kogan's courtroom and she said, "Did you do this?" I'm thinking, did I do what? I wasn't aware of the rule. But a rule that she has is you need to disclose as the plaintiff the names of your treating doctors even before discovery starts. So, and she will tell you to do that at the first status hearing. So what we've done now is, as soon as the defendant answers the complaint, we send a letter off saying, here's the plaintiff's treaters, go ahead, get the records. Get them now. Because you know that takes 60, 90, 120 days to do that. They won't accept the records for you. It probably, to me, I'm seeing it cuts off about 60 days of time in this whole F1, F2 garbage. The second thing that I've started to do that may increase the cost to our client, but it's going to reduce the time, is I am not waiting any longer to take F2 deps for the defendant. I was in a courtroom the other day where we have a cancer case. There's like 3 treaters. And we're, I don't know, a year and a half down the road now, and the first treater they tell me is available now February 13th. And this was 2 weeks ago. I'm saying February 13th, so that's 2 or 3 months from now. It's ridiculous. They're doing that because it's their schedule, what they want to set up. So we are now taking the depositions of our treaters. And in one sense, I feel better because I'm in control of it. In another sense, it's expensive because, of course, they're going to charge you for it. But it moves the case along. It moves it along, and it forces the issue to get to F3s. The other issue you face in some counties, my county, they have a position that if the defendant doesn't take, the treater's deps, they'll put a deadline on it, and that'll be the end of it. You can't take the treater deps. Well, that only hurts us because most treaters aren't going to talk to us anyway. So we need to bring out what they're going to say. So We have, across the board now, started taking treater deps, unless the defendant is very vigilant in getting the records and setting up those deps. And we've been doing it now for 5 months. I truly feel that this is going to speed it along. I see by what we have set now in 2012 for trial, which I don't think we would have set in 2012. So I suggest that you consider it, because we need to figure out a way to move these cases along. 30 months, 40 months is ridiculous. We need to get the justice at a sooner time. So that's all I have to say. I hope you enjoy lunch.